My esteemed senior brother, Judge, Honorable Justice J.K. Maheshwariji, Judge Supreme Court of India, other dignitaries on the dais and off the dais, it is indeed a privilege to address this august gathering, the delegates from various countries, jurists who have assembled here to deal and discuss on a very important topic in today's world, besetted with conflicts, challenges, where rule of law is threatened, and to reaffirm our belief in the rule of law, which is the foundation of democracy. Rule of law, in essence, means that the state is governed by laws, not by arbitrary rule, and no one is above law. It is a dynamic concept integral to the India's constitution, the basic structure, meaning that all persons, institutions and the state itself are accountable to publicly promulgated laws that are equally enforced and independently adjudicated. It ensures a balance between individual rights and the state power, promoting principles of equality, fairness and accountability, and it is the basic foundation of democracy. Today, as we are addressing this issue of global economic governance and the cross-border terrorism through the prism of rule of law, we are in fact examining how this timeless principle can meet some of the most pressing challenges of the 21st century. As far as India is concerned, as mentioned by the earlier speakers also, the concept of rule of law is not a mere colonial inheritance or a modern concept which have borrowed from other jurisdictions. It is deeply rooted in our ancient ethos and tradition and is based on the concept of dharma. The idea that dharma should guide the conduct of the individuals and the rulers is fundamental to the social order, which is our civilizational value. When it comes to governance, it is guided by what is called Raj Dharma or Dharma of governance. Then what is this Dharma? Dharma is not religion as it is misconstrued or wrongly understood in contemporary times. The word dharma is derived from the Sanskrit root dhri, which means that which holds and sustains. In Mahabharata, this concept of dharma has been explained in various chapters in every episode of Mahabharata, one of the greatest epics, where the clash between good and evil have been so beautifully portrayed in human terms. This concept has been explained from time to time in the various interactions between the kings, between the people, the rulers and ruled. Now, it explains dharma as something which nurtures, cherishes, and providing amply, more richly, and which enhances and increases. That is what is explained as dharma. It is also explained as something which supports, brings together, and uphold all the living beings together. And dharma also has been explained is something which secures all living beings freedom from fear and violence. Now, coming to this Raj Dharma or the Dharma of governance, Mahabharata says that when the king, with his heart and speech and body, protects the people and does not pardon a wrongdoing even by his own son, that is called Dharma of governance. Mahabharata also says that Dharma of governance is exhorting of the king to protect his subjects from their fear of the king, from the fears of others, from their fear of each other, and from the fear of things that are not human. Mahabharata also goes on to explain that Dharma of governance is wishing to control the wicked. The king must exercise control over himself first. Should his relatives do wrong, he should impose upon them severe punishments. Therefore, the concept of Raj Dharma, which is so beautifully explained in Mahabharata, in fact the foundation of the modern day concept of rule of law as we understand. Thus, it has always been India's own dharma, deserving our highest reverence and adherence and respect. As I see that there are very important topics, themes are going to be discussed today, and one of it is cross-border terrorism and rule of law, of course, where we will have a very distinguished speaker speaking. But I wish to just say a few words also on that. In fact, India has been a victim of terrorism. Since people may be thinking it's just a recent phenomenon. No. Since 1947, when India was declared independent, a horde of armed tribesmen came from Pakistan, almost reached Srinagar. They were stopped at Baramulla. When people rose against the invaders and Indian army had to intervene, that's how Kashmir was saved from the foreign invasion. From then onwards, it has continued unabated in spite of various understanding agreements and urging by the international community also, it goes unabated. The last being what has happened in Pahalgam. It's a real threat to the rule of law. This threat to the rule of law obviously impels the country, the victim, to resort to various means to prevent and stop it. In our anxiety to do so, we may try to then attempt to overreach the rule of law. Fortunately, this country has been able to resist that temptation. I'll give this example. All of us very well know of the incident of the Bombay attack, when 10 terrorists belonging to Lashkar-e-Toiba had descended upon the Indian soil through the sea route, created a mayhem massacre, unprecedented scale, which was captured live also. And they were captured in CCTV cameras. Unarmed, innocent passengers waiting for the trains in the railway station was butchered. People sleeping in hotels were butchered. People in market were butchered. Unparalleled. Of course, 9 of them also were killed in an encounter. 1 survived. Everything, all evidences were before us. If we wanted, we could have convicted in a single day. What evidence will require? Everything is all on the platter. But India did not resort to that shortcut. We decided that he must go through a full-scale trial. Any other accused, whether he is a foreign terrorist or any other criminal who deserves to be treated in the most human manner, fair, transparent trial. The trial was conducted more than a year. He wanted a lawyer from Pakistan. Pakistan obviously denied any role linked with these people. They did not bother. The Bombay, I think the members from Bombay Association, Bar Association, they also passed a resolution that we will not give any assistance to this terrorist. Chief Justice of India intervened. No, he deserves to be given a lawyer to defend himself. Indeed, a lawyer was provided to him. More than 1,000 pages of charge sheet. 80 charges were made against him. 86. He was given all the benefits. The entire legal system was operationalized to the extent it is practiced for any other accused in the country. Yes, he was convicted and sentenced to death. What I am trying to say is that there is always, of course, there was a huge popular resentment and anger. Hang him, No, because our deep-rooted respect and adherence to the principle of rule of law, we never jettisoned all those due process which is required of this due process. There is another aspect also. Terrorism has been continuing not only in Kashmir but other parts of the country also. Yes, we did make some departure when Tada, when Pota, which are specially enacted to deal with these terrorists, were enacted. We did make a departure. Under the Indian CRPC, any statement made to the police is inadmissible in law. There is a statutory bar. It cannot be used for any purpose. The statutory is very, very clear. It cannot be used for any purpose except for confronting or cross-examining that, the limited scope. Otherwise, it is of no value. It is only valuable to the investigators. Yes, a departure was made in this act, these two acts, Tada and Pota. That statement made to a responsible officer could be admitted. It was challenged also. There was hue and cry. There were popular demands that why are making this departure, because it has the potential of being misused. Ultimately, this also was dropped. And today, we have a new act, UAP Act. But this provision which makes any statement made to the police during the investigation admissible is no more part of our criminal justice system. It is nothing but a respect for the rule of law. Because rule of law demands that any investigation must be fair, any trial must be fair and transparent, and which is opposed to any provision which is considered to be unacceptable to a civilized society. I do not wish to take much of your time. Our honorable speaker, our chief guest also here, and we have another whole day. There will be a plenary session on different aspects of the rule of law. I am very, very thankful that so many participants from across the globe have assembled here. In fact, today, the whole concept of rule of law is not just a mere cliche, is not a cliche. It is a need of the hour. Without the rule of law, any society which claims itself to be a democracy is hollow. In fact, if you see around, open the constitution of the world, every country claims itself to be democracy. But do you really believe in your heart of heart? No. Because you know that the rule of law is not really respected or followed. It is this importance that we all assemble here to reaffirm our faith and to see that the foundation of rule of law remains sound, robust, and that is the basis for democracy, because without it there cannot be peace, without it there cannot be prosperity, without it there cannot be liberty, without it there cannot be equality. Thank you very much.